Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is how should we protect children's online privacy? Revisiting the Children's Online Privacy Protection Act. Previously at our Curious Amalgam, we explored some of the fundamental questions about a federal law designed to enhance the protection of information collected from and about children under 13. Namely the Children's Online Privacy Protection Rule, or COPPA. Today, we hope to focus on whether COPPA needs an update since its inception in the 1990s. Wow, that does sound like a long time ago. Joining me today is my co-host, Christina Ma. Hi, Christina.
Hi, Anora.
Would you please do the honor and introduce our guest today?
I'd be happy to. Our guest today is Ryan Durrie. Ryan Durrie is Associate Director of Policy for the Cordell Institute at Washington University in St. Louis. He joined the Cordell Institute after a career in private practice, previously as counsel for Amazon and Golub Capital. Ryan, welcome to the show.
Thank you.
We're very happy to have you.
I'm happy to be here. I'm looking forward to a nice conversation. I mean, there's a lot to dig into here.
There is indeed. And as Anora highlighted in a previous episode of Our Curious Amalgam, we explored some of the challenges with COPPA and privacy law generally, including some potential trade-offs of COPPA. But if you could help our listeners refresh their recollection, tell us sort of the basic framework of COPPA and what it is intended to do.
Sure. COPPA is, as you alluded to in the opening, it's an old law that's been updated a few times, but its last update was in 2013. And the intention is to protect children's privacy online. That's the whole point of COPPA. It's the Child Online Privacy Protection Act. Given how much our technology, our interface with the internet, how we interface just in our daily lives using technology changes over time, this is obviously a law that can't just remain static. It has to be updated, it has to move. And there's a pretty broad grant of authority to the FTC to create rules and regulations underneath COPPA. So the FTC has come out and asked for comments on some proposed rulemakings. And really the idea is to try and bring it more up to date and really more closely mirror some of the things that are occurring with the current internet as opposed to the internet in 2013 and certainly as opposed to the internet, back in the 1990s when this was first launched.
So let's rewind a little to the sort of the basic way in which COPPA attempts to protect children's privacy. Is it sort of a notice framework? Is it an affirmative obligation? How are people supposed to comply with COPPA?
Sure, absolutely. It's a bit of a mixed bag. It's all of those things. There's certainly a notice component, and there is a notice and choice, which is something I think we'll get into pretty heavily in this discussion, just as I think it's an area at the Cordell Institute we're extremely focused on. But it requires that websites that are targeted at children are taking certain cautions and steps to protect that information and are only using information regarding children for certain purposes. And in the case of COPPA, that's defined as persons under the age of 13. So it's not teenagers. I think that's something that sometimes people don't remember or know, is that it is narrowly tailored to much younger children, preteens basically. And so a lot of these protections don't exist for teenagers. And it's something that I think more broadly as a society we need to think about, but is kind of outside the remit of this discussion specifically. Some of those controls are about how information can be processed, what information can be kept about children. So there's a lot of prescriptions around websites and online platforms that are targeted to children. And then there's something else we'll talk about in the updates, or the proposed updates, is what they call the mixed use websites. And that is where it may not be specifically targeted to children, but children are part of their targeted demographic. Those do currently fall into the more prescriptive and more structured areas of COPPA and aren't kind of opted out at something where it's only de minimis or incidental that children would be using the website.
Okay, so you noted, a lot has changed since the 1990s. A lot has even changed since the last amendment in 2013. What are we trying to solve for? What has changed in our online use or in children's online use that requires us to revisit COPPA?
Sure, quite a few things. I mean, just think about did you have a phone in your hand as often as you do now, even in 2013? So sort of the ways we interact with technology and how much children are using it and how early. And then related to that is, what are businesses doing with the information they're receiving, and what is allowed use, and how have businesses and industry and the FTC interpreted current regulations, and where are there some gaps? Some of the things that you would think about are, for example, notice and choice, the type of notice that's given. Does it need to be specific? Can you get a broad notice? Who has to give that notice? Some of the areas where it will intersect is with FERPA and some of the regulations around how schools can use student data. And we've seen updates around that to try and give more guidance. And that's obviously a very complex area because it's not just the FTC there. There's multiple agencies that need to regulate and understand who's giving consent where. And then relatedly, and something that I think has gotten much more attention recently, are how these websites are being designed and what they're doing with advertising. And then also in things like nudging or attempting to increase engagement. That's changed over time. The sophistication of those efforts by websites and by companies are just much better now. They're much better at nudging. They're much better at bringing, think about phone usage. Everyone thinks phone usage goes up over time and you have to actively combat it and think about how's this happening. A lot of it is just the fact that companies are better at making more engaging products, for better and for worse. And so that's the reality that I think we need to start addressing. And I think the FTC is attempting to address here.
Yeah, so let's take those in turn. Sort of
Sure.
First, I'll call advertiser nudging. So what do the FTC's proposed rules do to address increased sophistication in that nudging?
You could argue they don't do a lot to address it so much as they try to just make people aware of it. So they take it out of what is called the operational exception, which is sort of this idea that for operations that are required, internal operations that are required to make your website work, you are allowed to sort of get around some of the consent requirements because it was deemed that you had to have that to make your business work, and that was a reasonable thing. The FTC in these updates is making it clear that you can't use that exception for consent to nudge, to do things that would, I think the term they used was encourage or prompt use of the website or online service. So that's outside of now like that operational exception. You need to get now, under the FTC's proposed guidance, clear direct consent from the parents of or the guardian of the minor.
So the position previously was, I need the nudging to operate and to get use out of my application or site. And now the FTC has put that outside of that exemption.
Yeah, and in fact, it narrowed that operational exception quite a bit in other ways as well, sort of classifying what type of information can be kept there. And then they've also limited the type of data that can be kept and how long it can be kept. Data minimization was always part of COPPA, but sometimes was taking a backseat or maybe not as emphasized. And in this update, the FTC is making it clear, just almost restating, everyone, data minimization is a requirement under COPPA, and you should only be using this information for the specific things you need it for, and only keeping it for as long as you need it to fulfill those specific purposes.
And then you had also mentioned, I guess, FERPA related to education data. What are the amendments doing in that regard?
Sure. They're actually loosening a little bit the consent to deal with the reality that often it would be impractical for a ed tech provider to actually go through the schools and get to every parent. But it is practical for them to have a contractual relationship with the school that they're working with, and for them to rely on the school to then get the appropriate consents or to confirm that appropriate consents have been received or that parents are informed. And then there's requirements for the ed tech companies to also disclose that on their websites, things like that. They do receive this information. They still can only use it for educational purposes, but making sure parents could find out that way as well, that their children's information is being brought over. So in that case, they're loosening it, but it's more to, a fact on the ground. You don't want regulations to actually not make sense in practice. And in practice, you're just not going to have an ed tech firm that's going to every individual parent at every individual school.
Yeah, certainly a gap that was probably highlighted during COVID. So to help frame COPPA with how others handle online privacy, particularly for children, how does the U.S. framework compare to how other jurisdictions or even states regulate this behavior and conduct?
Sure. I mean, it's in line with a lot of what goes on in the U.S., but there are states that are moving to more restrictive areas, and it's in particular carve-outs and specific types of issues. It's pretty in line generally with how the U.S. has looked at this historically, but some states are starting to challenge that in specific areas. And in the new FTC regulations or proposed regulations, there's talking about things like specific consents for each type of use of data. So you can't just get this broad general consent and say, hey, we might use your data to do something. Consent. You need to start laying out specifically what the purposes are. And in particular, for example, if you're going to nudge, there has to be a specific notice that, hey, we're going to use information to potentially nudge your child to use our services more. Or if they want to use that for third-party advertising, they're going to need to let you know specifically that's what they're doing. They can't use an internal operations exception to do that as well. I think where there's some concern in this approach and where it doesn't potentially match up with how some other jurisdictions are looking at this more broadly is notice and consent as a whole has tended to fall down over time. And if you think about what it is that notice and consent is trying to do, is it's trying to allow parents to understand what's happening and make intelligent decisions about their children's privacy. That's the lofty goal. In reality, that's not what happens. No one is reading all of these consents. And in fact, it's almost pernicious in that it's shoving the blame onto parents, saying, hey, you got notice, you got consent. If something happens you don't like with this data, we got the consent. That's on you. You should have read this more closely. So it's creating this burden on parents that I don't think we're getting as much of a benefit out of as we should. And this sort of change to additional consent, it really just exacerbates the problem. There's a study from 2008 that if you just skimmed the privacy policies of the websites you visited every year, just skimmed, didn't even read in depth, it would take you 154 hours. And that was in 2008. It's only bigger now. We did just a back of an envelope sort of check of about 17 websites of companies that would generally be targeting children. And we found that it would be several days worth of reading for a parent to read all of their policies, including everything. That's not a realistic expectation for anyone.
I can validate that anecdotally as a mother of 3 kids under 13, that I can barely keep track of my own cookies, let alone my children's cookies. But I guess the alternative is just to take all the screens away.
And that's sort of what everyone wrestles with is there's obviously great things that EdTech and children's programming and all those things are doing, and we want to enable those things, but we want to do so in a way that's protective of children and is focused on children's best interests. And so I think there's more we could do in this space, and more I think that the FTC and other regulators can start thinking about and presenting and maybe playing around with ideas around things like a duty of loyalty, of data loyalty, or acting in the best interests of children when we receive their data.
So let's start all over, right?
Mm-hmm.
We're coming up with our own children's online privacy sitting here today in 2024. What should it look like? What could we be doing better or different than the current, as you describe it, notice framework?
Yeah, the king of the world question. This is always a tough one. I suppose I would start, and it's something I've written about and we work on a lot at the Cordell Institute with a lot of our fellows, is around this idea of data loyalty. This is especially coherent around children and a strong protection for children because of the idea that what a duty of loyalty is allowing you to place trust in someone who has an information asymmetry with you and a power asymmetry with you, that they're going to act in your best interests. For children, that just makes sense. That's how they should be interacting with companies that are going to market directly to them, that are going to sell products directly to them. Those companies should have a requirement legally to act in the best interests of the data subjects who they have their data. I think if you start there, and then it's something in the literature they'll call the privacy two-step, but the idea is you basically start with a broad data loyalty. And I would argue it should be broader than children. I would say there should be a broad data loyalty statute in general. If people are accessing data and using it, they should be using it in the best interests of their subjects. And then you go into understanding that broad statement's great, but how do I deal with, in brass tacks, in what specific relationships should this be a stronger or more muted duty? Where should we look at how to craft the law to make sure it's not overly stifling to companies that are allowed to get things done and to innovate for us, but not taking innovation as sort of a shibboleth on its own and acting like innovation is just an unalloyed good. It's not. It's for and to do certain things and for and to benefit certain people. So we should be thinking about who's benefiting from this innovation and what's restraining innovation in an appropriate way, but allowing it to flourish where it should.
So obviously duty of loyalty is a more amorphous term. Mm-hmm. Do you think a duty of loyalty would prohibit companies from selling their user data, or how they sell the user data, or who they sell the user data to, right? So what are the parameters of how you would think about a duty of loyalty?
Certainly. I think it could. It certainly could. And I think what it does is it focuses on the relationship as opposed to a transactional nature of the interaction. And so it does allow the company to think more holistically about what's best for their customers. There was a quote from Senator Schatt, I believe, in 2022, where he said, a duty of loyalty is really only a problem for the bad companies. Good companies understand that over time, the best way to grow is to build loyalty with their customer base and show their customers that they are loyal to them. It's a two-way street. And they actually work in a win-win relationship with their customers. So I would say it could. And I certainly think there are instances, for example, with children, I could make the argument that there really shouldn't be targeted advertising for children at all. Maybe contextual advertising is fine. If they're on a toy site, we can advertise more toys, but targeting down to this specific 11-year-old likes Transformers, so let's get Transformers in every site they go to. I'm not sure that's necessarily necessarily a good or a needed thing.
I remember when all the streaming websites went from advertising or free to advertisements, and my kids were like, what is this that's disturbing my content? And I was like, it's an advertisement. Get used to it. And now the commercials are so targeted that I actually wish we didn't have those commercials, because every single commercial that comes on, they want that toy.
Exactly.
So it's, the table.
And I think it's just one of those things where as you, and this more I've thought about this even over my own time, just kind of grappling with how do you address both the great goods that the internet's bringing, and it unquestionably has, against sort of where we see it. Maybe are we emphasizing returns and specific, nudges of a certain percentage in click rates as opposed to what's best overall, and we can still earn healthy returns, advertise in a way that's helpful. It is helpful to know, hey, I was thinking about kayaks. I went to a kayak site. Hey, here's some other advertisement for a place that's got a sale on kayaks. Great. Maybe they don't need to know that I'm in St. Louis. I hike frequently. I bought this stuff from REI. I bought this stuff from Amazon. That type of thing maybe is something we should think about, whether the utility that adds to the company is worth the cost it has in time, attention, the potential for nudging and other misuse against, what they're gaining.
Earlier on, you mentioned that the current statute covers children under the age of 13 or 13 and under, so not teenagers. Obviously, a number of social media companies have come under attack, particularly, I think, focused on the teenage age group that can get, where there may be social ills to teenagers in particular using these websites. Do we think that that would fall under a duty of loyalty, right, around sort of mental health?
Yeah, I would propose the duty of loyalty personally broadly. I would say it's not just for children. It should cover adults as well. Now, that's where the two-step comes in. I think children and teenagers and minors would have more protections. And in certain cases, you would say, look, if you're an adult and you decide you want to do something and it's very clear you want to and you're getting appropriate disclosure, great. But disclosure can't be the only hook. It's just falling down when it is, because it's impossible to keep up and have meaningful discussion. I think what duty of loyalty does is, since it focuses on relationship, you model it a bit after some of the one of the ways to model is after some of the professional relationships you have, like in finance, ourselves in the legal profession, doctors, ideas where it's when you're making a decision, you give them the information they need to make an informed decision, but you also have some guardrails around them where you're like, I'm not going to let you make this decision because I know it's bad for you. Because there is an information asymmetry here. There is stuff that I know that you don't, or that I have power over you that you're not aware of. So I do need to act in your interest.
So this touches on, I think, some of the trade-offs we had discussed in the earlier Our Curious Amalgam episode that talked about COPPA, and in particular, the less data that content providers can use or retain or sell, there's arguably a trade-off in terms of innovation, better content, better services. Do you think that's a valid criticism? How should we think about that in the context of a duty of loyalty or otherwise?
Sure. I think there's a valid criticism in that I'm not, and I don't think anyone would, or I wouldn't agree with, no one should be able to use any data to make anything better. That's silly. Obviously, there's instances where companies have information and they want to improve their products. Even just looking at COPPA, that internal operations exception, actually improving your product is allowed. It's, that is one of the reasonable reasons to use the information. So I think we can try and find the midline there. And part of that will be that two-step, the placing specific duties around technologies maybe where we don't want them doing this. For example, maybe AI is something where legislatures need to get much more in-depth into what type of AI and what uses of information do we want happening, versus maybe more broadly if you are creating a more optimized web experience. Knowing that there are things like dark patterns and other sort of controversial issues around nudging. But if it is truly just, we're going to make this more efficient, we found people can click through better here. When we did a user survey, we found out they like this site better than this site. That type of thing they definitely should be allowed to use it for. That is obviously, I'm not giving you a crisp answer here simply because you'd have to look at specifics. But I don't think it's an intractable problem, and it's something, legislation and courts have had to do since time immemorial. What is the payoff between technology we want to advance and that we don't? And what's a safe use of our information ourselves versus what's not?
And if we were to continue operating in this sort of notice and opt-in, opt-out model, is there sort of an in-between what we're doing today and the duty of loyalty that you would think would address some of these issues that you've identified?
Sure. There have been a few proposals. One was APRA, which was a proposed federal privacy bill a couple years ago that had almost like you could call it a duty of loyalty light built in around a lot of sort of like data minimization and other things you'd find familiar from COPPA and GDPR. So you could go somewhere in the middle. It's still going to lean heavily on notice and consent, depending if you're not creating those internal inherent protections. But it does provide, I think, a stronger structure than currently exists. Well, certainly for adults, since no federal sort of statute exists currently.
Sorry, so you mentioned that it has elements of GDPR. Which particular elements of GDPR?
A lot of the notice and information around data controllers, data subjects, things like that. So sort of having much more understanding of what's happening in data flows and requirements around what the data users are doing.
Understood. Yeah. I mean, I think there's a lot of nuance there. I think that at least as I read COPPA, there's not currently different rules for different types of commercial players. And some of the things you're highlighting is that there may be commercial conduct that we would want to encourage more. Although I guess with this ed tech thing, that is one example where we're trying to encourage that more. But there could be situations where you would regulate different actors differently and impose different levels of duty of loyalty across the.
Yeah. To your point earlier, maybe one way to think about it would be a company that is gathering data from the direct users to improve their product. Maybe we are somewhat less suspicious of that or more allow more there than we do, say, a company that's its sole business is to just aggregate data and sell it. Maybe we say we're more worried about that second company.
I do have a follow-up question about, this a little bit amorphous concept of duty of loyalty. Are you expecting more litigation?
If you create a brand new statute whole cloth, you're going to have litigation under it that didn't exist before. Do I necessarily think that it needs to be created in a way that creates extensive litigation? No. I also, though, would challenge whether just saying there's litigation is a bad. If people are actively violating a law or breaking a duty that they owe to someone, there should be a way to vindicate that right. Now, you can craft the law in different ways, whether it's carve-outs for small businesses or limiting the private right of action in certain ways. But I do think if you're going to create a right that people have and a duty that's owed to them, they should have a way to stand up and say, hey, my right has been violated, and there's some way to address it.
Ryan, so you must have heard, in the earlier part of the show, we mentioned that the FTC is in the process of trying to update the COPPA, right? And that's in earlier part of 2024. And where are we in that process? And what do you expect it will come to later in 2024? Are you expecting any major updates?
It's hard to handicap for certain. Obviously, the regulators are going to act as they want, but I believe comments were due on March 11th. And I'm trying to remember my Civ Pro, but I believe they have 90 days from that to then issue something. They can take longer, but I think there's at least the 90 days from that for them to digest the comments and act. And if anyone's listening, I'm wrong on the 90 days, I apologize. But we're basically we collectively as a community have provided comments to FTC, and they're now digesting them. And I would expect, if I was guessing, sometime in the next month to see some sort of update from them. But I don't have any, there's no inside baseball there. That's my guess.
Another question, and that's sort of like, floating around, is that, people have often criticized that the U.S. privacy regulation framework is a bit of a patchwork, right? And that's sort of like in contrast with GDPR that the Europe has come out of just a couple of years ago. And then do you see the FTC's update to COPPA? I guess that's they're only an agency. They're not Congress. They cannot really do a revamp of the whole framework. But is there anything like floating around sort of like the underlying criticism of this patchwork system that you see that can be addressed, understanding that today's discussion is focusing on only one of those patchwork?
Yeah. Obviously with COPPA, they have jurisdiction over the U.S. for that portion. So they can try and set their level or their kind of the floor or the ceiling, depending on how they draft their regulation. I would love to see a federal regulation, but I would want it to be implemented as a floor, not a ceiling. I wouldn't want it to be a preemptive one, simply because the states have been incredibly effective in helping us move privacy forward in productive ways. For example, I believe we got the idea of the event reports or the intrusion reports from California law, and then that sort of got taken up more broadly over time. So I think there is a place for the states to look at things and sort of our whole idea of the petri dishes of the states trying things and seeing if they work. But I do think there should be a federal baseline and a federal sort of level set. Also for companies to know, hey, if we hit this, we know we're generally going to be fine. And then you can deal with any one-offs and figure out how to go from there. And I think having a federal statute would also just inherently limit the patchwork in some ways, because certain states are just not going to do anything then. They'll be happy with, okay, great, there's a federal law that does enough, so we're done. And so you might actually create less of a patchwork by having that in place.
That's fascinating. I'm sure there's a space to watch. And then if there is anything that that's hugely changed, we're going to have to invite you back for more questions.
Absolutely.
But before we let you go, we usually take the opportunity of interviewing you to let our listeners to learn a bit about you more personally. So we want to do that here. We wonder if you could share with us maybe just one thing that people who only work with you professionally would not know about you.
Oh, that's a good one. I am an avid outdoorsman. I love cycling and hiking. And then
I think we already got that in the early discussion.
Yeah, I've gotten it in twice already. And somehow that I still moved from Seattle to St. Louis, but that's for a great opportunity. And then I'm also really enjoy jiu-jitsu.
Oh, that's fascinating. Did you get any targeted advertising? I don't know actually what products would be for jiu-jitsu cushions.
Gis, belts. Yep, absolutely.
That's great. We also have a section that's somewhat silly, commented by some of our listeners. It's called Our Curious Hat.
And now it's time for the Curious Hat.
Christina, do you want to do this to pull out the magical hat?
Here it is. Ryan will ask you to draw a number 1 through 20.
17.
17.
17. Let me read that question. So, because we tried to update the questions because people think some became stale. So, if you were given $50,000 on the condition that you had to spend it all in 1 hour, what would you buy? I guess I would suspect some like jiu-jitsu gears or something that you just mentioned, but if not those.
Actually, travel. I would figure out how to spend $50,000 traveling very quickly.
Sounds like a good idea.
And where would you go?
Oh, good question. I am embarrassed to say Southeast Asia and Australia in general, I have not been to, and I would love to get there.
Well, I'm sure you'll get some targeted advertising sometime. Thank you for joining us today, and thank you for listening, listeners. Until next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.